Hi, everyone. Carl Steinbeck. Just wanted to cover day 3 of the motions today, and just want to start out by something that really was disturbing to see, and that's listening to Hank Brennan talk about why the third-party culprit defense should not be allowed. This is so extreme and outrageous for a prosecutor to be arguing this. It makes absolutely no sense at all. When you really stop to think about it, what he's saying is that Karen can't present any defense whatsoever other than the fact that she didn't do it. Imagine that. I don't think the audience maybe grasps how serious and how unconstitutional this is to box their lawyers in to say they cannot argue that somebody else did this. They cannot question other people to point the finger at them because all the people in the house said they didn't do it. And they have no idea where John O'Keefe went. So that's what due process is in the attorney's office there in Norfolk County, Massachusetts. It's just an absolute abomination and trashing of the Constitution. They have no clue what they're doing there. It's actually just a rigged system, because when you stop to think about all the motions that they've had to keep out evidence, it is like, I think it was not Yannetti, but Alessi that said it's almost like their defense trial counsel, like in the Donna Adelson case, they're trying to keep out all the incriminating evidence. Okay, they're trying to keep out the divorce records, the 456 pages or whatever it is of divorce records showing how a contentious knockdown, drag-out battle there was between the deceased Professor Dan Markell and his ex-wife Wendy Adelson. They're trying to keep out the jail records where she talks about fleeing the country. They're trying to keep out all the information that the jury would use to base their conviction on. They want to keep it all out. So if it's really negative against Don Adelson, they want to keep it out. Well, here you take the inverse of that. Everything that points to reasonable doubt or innocence of Karen Read, this prosecutor is trying to keep out. He's trying to keep out the ARCA witnesses. He's trying to keep out all this information that is favorable. Think about the other experts that he's given grief on. He's actually trying to intimidate and in my mind, he's basically trying to prevent ARCA from being cooperative and wanting to take part in this trial again. That's how much he's going after him, and he's calling him biased in open court. People that they're just doing their jobs. They're calling it like it is. They have no skin in the game. There's no axe to grind. No matter who pays them, they're not going to do anything but tell it like it is with their super advanced degrees and experience of many decades. So that's the kind of thing that Karen Read's counsel are faced against. And so, as I've said before, the only way Brennan is going to get a conviction is by hiding the truth. Okay, and that's something you don't see much from prosecutors. You can see them hiding the ball much of the time. But this is like the worst case example you'll probably ever find of a prosecutor basically cutting them off the knees on everything that's favorable to the defense. And guess what? We do have a Constitution that's supposed to stop that kind of thing. It's supposed to stop people like Hank Brennan in his tracks, stop them cold. He has a duty for justice, not to win a conviction. So his tactics to deny experts, to deny them to present the defense that somebody else did it, is just mind-boggling. It so far runs afoul of the constitutional due process requirements. There is a constitutional right to present a defense. Case law talks about that. In the motions cited by Brennan and also by the defense, they don't mention the Supreme Court case law, but there's Supreme Court case law on point that's well founded over many decades that talks about the constitutional right to present a defense. There's compulsory process of obtaining witnesses in your favor. So you can basically have people there to defend and support your theory on what really happened. And so for a prosecutor to say, no, you're not allowed to say anything other than, no, you didn't do what I'm accusing you of doing, it's just very much, like I say, it's a farce, it's a sham for due process. And it's something that every citizen in America, if they see this kind of stuff going on, they should really be shocked and appalled that they cannot argue that there's other people that could have done it. And there's other people, they mentioned 3 people, but I think the implication is also that besides those 3 people being involved in it, they want to be able to argue that others knew about it and helped cover it up. And so besides just the three things that the three witnesses that were cited in the defense motion for reasons why they should be allowed to have this third-party culprit defense, there's other things as well besides just their motives. There's actually other digital evidence that shows that something else happened other than what the state is saying happened with Karen Read being the guilty party. You have the digital evidence. You have the fact that, as I said, the alibi defense, that Karen Read was at John O'Keefe's place at 12:36, and yet the prosecution was arguing in trial one that, at least in their opening and through witnesses like Trooper Paul, that the so-called murder happened at 12:45 in the evening. So she was already home at that time, at John's home. You also have the digital evidence showing that John had gone up and down 3 flights of stairs. So what was he doing? Levitating out of her car and go up and down some levitation thing to be able to then lay down in the yard and then then just lay there and wait till 12:45 rolls around. Keep in mind also the many extreme behavior actions that were not fully cited in the motion, if you see that. One of the things, sorry, I was running a little late here. One of the things I realized here, I'm using StreamYard to do this live stream, and when I'm showing you the screen of a multiple page document, it's not letting me scroll through the screen. I was not aware of that. So I was trying to see if I could do a workaround for that. So it's not allowing me to show the documents. Otherwise, I would like to show you the documents and walk you through some of that tonight and just really show you how there's even more details that the defense could have put in there, showing how the actual evidence, besides the actions of those 3 parties that they named, which is Colin Albert, Brian Albert, and Brian Higgins, those three men, that there's actual digital evidence as well. There's actually other things as well that were just highly suspicious and irregular. All the actions of those 3 and suspicious behavior does give cause to have someone asking the reasonable question and inference and argument that they were actually the ones behind something. You also have the dog bites, considering the fact that you have expert testimony besides the ARCA witness that said this is not damage you'd see on this vehicle from a pedestrian. Okay. Then on top of that, you have a medical expert saying that this is dog bite or animal type bite markings on John's arm. That alone shows that there's something other than Karen Read involved in this, right? And then you also take into account the fact that the suspicious movement of the vehicles, that Ford Edge was placed out there. You have the plow driver, Lucky, that talked about how there's no body laying there. And then it's very unusual for this Ford Edge to be parked there. They're not supposed to be parked there when it's snowing. They could basically get cited and fined for that. So you also have the effort of the prosecution to keep out the cause of death. This has got to be the first time in the history of the world a prosecutor of a murder case is trying to keep out the cause of death from the medical examiner. Can you believe that's how much they got to hide the ball in this case? It's just absolutely just astounding. It's just so baffling. It just makes your blood boil. But you know what? The one thing that I keep reminding myself is that at least people are getting to see how bad it can get. At least you all, as a viewing public in America and around the world, can see, if you don't have checks and balances in a judicial system and you let prosecutors run amok and just willy-nilly charge people, and they don't have to have evidence to back it up, and they suppress evidence that shows that they didn't do it or that other people could have possibly been involved. They don't have to prove that somebody else did it. That's not the defense's job. They don't have to prove anything under our Constitution. The burden of proof is on the government. And if they want to present something in their defense, however, they have and should have, as the Constitution affords, the right to present their defense on what they think happened. And if you have a prosecutor that's trying to cut them off the knees, even trying to hide their own evidence, they don't want the medical examiner's report coming in. They're not even going to call the medical examiner. Who's ever heard of such a sham trial like this? So if Karen Read is so guilty, why do you have to stoop so low and trample over so many constitutional protections? Ask yourself that. They should allow any expert they want, unless they're going to call like the same expert to say the same thing over and over and over and over again. You can have cumulative evidence that it's not worthwhile. It's going to basically be cumulative to the jury, and it's not for the sake of judicial economy and deliberation of the issues. It's not going to be helpful. So there's not an absolute right to bring anything you ever want to present in your case. But when you have these kind of accusations and you have forensic evidence that actually backs up the defense theory in multiple different ways, multiple different levels, the prosecution cannot even say exactly what happened. They don't know exactly what happened because they know that they have to know that Trooper Paul's testimony makes no sense whatsoever. For John O'Keefe to go spinning up 30 feet in the air and contorting his body the way Trooper Paul described it, it just belies any kind of common sense. Any medical person who's looked at this, the photos, the autopsy photos, which, by the way, there's no scene photos, right? There's no photos of the scene where John's body's laying in the snow. There's no pictures showing what supposedly was on his chest, fragments of the tail light. There's no pictures of the tail light at the scene. There's no photos of the scene at all. They did not treat this as a murder. They want this swept away and expedited and brought back to all places Canton, the vehicle for Karen, brought back to Canton. So there's so many things about this case that are just an absolute disgrace for the standards we uphold and expect of law enforcement officers and the prosecution teams that back them up. So anyway, I'm just gonna go through here now and show you the arguments of Hank Brennan, and I'm just going to stop. And if you guys have questions, I can stop and we can talk about this, because it just, like I say, it just burns my hide, and I'm just, disgusting, and it's just absolutely sickening to see this stuff going on. So let's just walk through this here. I'll give you my comments, and I'll stop to address some of yours as we go along here. So.
The Commonwealth or the defendant want to be heard on that.
I got the sound all the way up. Hopefully this is good enough for y'all.
So I'll hear you, Mr. Murder.
I'll put the closed caption on. They call him Mr. Murder in the closed caption.
Your Honor asks for a proffer from the defense regarding third-party culprit. Alternatively, evidence that would be separate regarding third-party culprit aspect of Bowden. We received some information from the defense that does not distinguish whether their intention is that it applies to third-party culprit or whether it applies to a third-party culprit aspect of Bowden. Those concepts are logically and legally distinct.
Okay, the Bowden is it's evidence to show the inadequacy of the police investigation. So bringing up questions of witnesses and pointing the finger at them, that's another principle under Massachusetts law, and Bowden is the name of a case that this is founded upon. So you basically can attack the government's case and cause reasonable doubt under Massachusetts law and across all of America, I might add. Is to show that the police investigation was botched. In this case, there was really no investigation whatsoever, other than a completely biased sham job by Trooper Proctor. And so the other prong of this, though, is the Sixth Amendment one, to right to present a defense. So although they don't mention the Sixth Amendment, this is really the foundation bedrock for why you're able to present a defense here in America.
Regardless, when you look at the proffer by the defense, it is insufficient and inadequate for both third-party culprit and for
why do you care?
Third-party culprit aspect of Bowden. Two different analyses.
Why do you want to deny a fair trial?
But the evidence is equally feeble for both.
Feeble? Really?
Relative to third-party
Of a botched investigation? That's feeble?
There are a number of cases that I know Your Honor is aware of that guide the standard of third-party culprit.
The trooper got fired over his biased behavior.
Because it is clear. but there must be relevance, there must be a substantial nexus between the claims of the defense and the third-party culprit theory. They provided us 3 people that they identify as third-party culprits. It's helpful just for a quick synopsis of the history. In this case, prior to the first trial, the defense never identified a third-party culprit. At some point, the defense
That's irrelevant. What happened in the
said
first
that
trial?
They knew who the third-party culprit was, and recently, the position of the defense has shifted that they don't know and don't need to know. Now, the law accommodates specifically identifying somebody. It also accommodates general, but it has to have specificity in the complaint. There has to be a motive, an opportunity, and an intention. There has to be evidence that drives the correlation. It can't be bad character, speculative, or just putting out information that's negative towards a witness so that that can backdoor prior bad acts against a witness and be used for a different purpose.
Can you believe what he's saying? So he's saying that it can't be speculative. You have to have concrete proof that these witnesses were involved. That's not the law. That's not the requirement. If they're acting suspicious, if they were there and their evidence looks like John O'Keefe went up and down numerous flights of stairs, that's all it takes right there. The fact that you have all these witnesses in the house, some people say there's 30. There's not 30 witnesses in that house, okay? But for however many witnesses there are in that house, every one of them could have been involved, or they could have been a witness to what's involved. And it's very easily done to have people to lock their lips, agree not to testify to what really happened. And you could very easily have somebody like a detective, a homicide detective, or a detective from the Boston Police Department. I guess I take that back. He wasn't a homicide detective, but he was a detective of rank. He had 30 years experience in the Boston Police Department. You tell me he couldn't command what was going to go on in this house, what people were going to say. That's certainly possible. And what happens here, because it's possible, it should be allowed into evidence to present a defense. Defense does not have to prove that he was involved in that as the owner of the house. They don't have to prove that ATF agent Higgins was involved in it. They don't have to prove that Colin Albert was involved in it. All they have to do is poke at them and make inferences and make accusations if they want. That isn't it true that you're the one that's responsible for these injuries? Isn't it true it's your dog that was doing this? And it could have been something that just went out of control. Maybe John O'Keefe just went to the side of the house to go to the bathroom, and lo and behold, he went through the back gate, and there's Chloe maybe attacking him or something like that, and maybe just scrambled to try to cover this thing up, and maybe they just decided to put him out by the street. And anyway, there's any kind of scenario that could be imagined by different people. Nobody knows. That's the point. Nobody knows exactly what happened. If nobody knows, the defense has the right to say, this is one of the theories. And because you have the evidence I mentioned earlier, this is why this is totally constitutionally required.
They identified one person, Colin Albert. And in their proffer, what they offer, number one, and it's important to take them separately because it shows how feeble it actually is. The first thing they say about Colin Albert is he had a feud with John O'Keefe in the weeks and months leading up to January 29, 2022. Now, other than maybe on social media or in interviews with the defendant.
And you know what? It doesn't have to be a feud that led up to this to have the motive. The motive could have happened right there. The motive could have happened without anything happening before it. And because you got that physical forensic type evidence, something else happened, and the prosecution does not have a cogent, logical, credible story on what happened to lead to the death of Officer John O'Keefe.
And national broadcast, there's no evidence of that. There was no evidence that's going to be admitted at this trial that shows there was a feud between Colin Albert and John O'Keefe. There is no evidence that there was.
Okay, you know what? Maybe that will come out through cross-examination. Maybe rigorous cross-examination will expose something like that. And he's wanting to cut it off so that can't even happen. I've had a case completely crash, I'm thinking of right now, where the alleged victim invoked her rights to counsel and did not want to cooperate anymore with the testimony because the lies were so bad and exposed so bad that the witnesses crumbled right there on the witness stand. Okay, So how do we know that won't happen in a case like this? Brennan doesn't want it to happen. He knows that all this kind of stuff hurts his case. All this kind of stuff makes people have reasonable doubt. Think about it. He's trying to make this case out to be just like a DUI on the side of a road, a hit and run DUI by Karen Reed. And what does he do? He's calling all these witnesses at the bar. He's calling all these witnesses at the house. Why is he calling all these witnesses? If they had nothing to do with it, and this is such an open and slam dunk case against Karen Reed, why is he calling all these witnesses to talk about what they're doing, where they went, what they saw, where's any disgruntled behavior between Karen and John, and how are they interacting? What time was everybody getting there? What time did all this go down? What time did somebody leave or show up? What does all that matter other than Karen and John showing up there and then Karen supposedly hitting him and taking off? The reason why is because they know there's reasonable doubt. They know that there's an issue of credibility with these witnesses. So what is the prosecutor doing? Instead of making this look like a simple DUI case where we know who hit it, after all, she admitted to it, right? She confessed to it to multiple people. So they have all that strong evidence. Who cares about all these people in the house? They got right there Karen's supposedly own admission. They supposedly got her damaged vehicle as proof right there. But the reason they got to call these other witnesses, the ones that the defense wants to go after, is because they know how weak their case is. And the only way they can try it is to suppress all that reasonable doubt from coming in, which is actually the truth from coming in.
Any hostility between Colin Albert and John O'Keefe. There's no evidence of a motive to kill John O'Keefe by Colin Albert. There is no evidence of any motive, of any intention, or of any opportunity whatsoever. In fact,
they have a right to probe for that.
Colin Albert was not even at 34 Fairview at the time John O'Keefe arrived there on January 29, 2022. And so simply saying it is not evidence. And an attorney should not be allowed to confront a witness about an allegation that has no factual basis for them to then have to defend the accusation. The prejudice then seeps to the jury, and the Commonwealth is in the position of having to disprove.
So the prejudice seeps to the jury? In other words, the jury cannot think in anything other than she's guilty. She's guilty. All the evidence is put your mind in a tunnel vision. Don't think of any reasonable doubt, because Brennan's going to keep it all out. All the reasonable doubt he wants to keep out. In fact, what I think is a good thing to do is to talk about, I'm going to do a presentation on all the reasonable doubt points that we can raise in this case. All right. So there's so many of them. All you need for reasonable doubt is one reasonable doubt, right? It's beyond reasonable doubt, not doubts. Okay. And they're reasonable doubts. And there's so many things that make you scratch your head and go, that's really odd. I don't feel comfortable saying that somebody can be guilty of murder when none of the forensic physical evidence, none of the physics that we heard about from the ARC witness, none of that adds up to make any sense to what the prosecution's saying. None of it makes any sense. The only thing that makes sense is that something else happened other than what the state is saying Karen did.
Prove a claim that had no basis to begin with. The second claim that they make regarding Colin Albert is that he had thrown beer cans in Mr. O'Keefe's bushes and told Mr. O'Keefe to F off in his face. There is no basis for those claims. There is no witness for those claims. There's no information regarding those claims. I understand there may have been a party.
Okay, you know what? There doesn't have to be. This is spin by the prosecutor, because you know what? If Karen knew about this and she told defense counsel have good faith basis to go after him and say, isn't it true you were throwing beer cans in the yard, trashing up John O'Keefe's yard? That's a perfect legitimate thing to do. So again, he keeps on saying no evidence, and that's a complete misleading statement on all this stuff.
Where there was beer cans, but there was no Colin Albert. So to attribute a situation or incident to him, the defense would need some good faith proof, actual proof, fact, that this actually happened. And there's no evidence whatsoever that Colin Albert threw beer cans in Mr. O'Keefe's bushes and told him to F off. And the reason there's no proof.
I can tell you, I do that all the time as a defense counsel. My client tells me something, you got the government's witness, the alleged victim, or any other supporting witnesses, and the prosecution doesn't know about all this other behind the scenes events that happened that make this prosecution witness completely incredulous. And so what I do is I bring up all these other details. It catches the prosecution off guard. The witness doesn't think this kind of stuff is going to come out in such a wire brush fashion. And then that's the whole thing about the Sixth Amendment and due process clause of the Constitution, is that you have to test the evidence through rigorous cross-examination and by bringing your own witnesses to challenge the government's theory. So none of this seems to be at play there in this Massachusetts court.
Is because it didn't happen. So again, the defense asks for an invitation to simply cross-examine a witness, allege a prior bad act, and then the witness has to defend their honor and the government has to disprove it. That is not.
That's how trials
law
work,
that
Mr.
third-party
Brennan.
culprit is made from.
That's American justice system.
Regarding the suggestion that there was some type of feud or tough relationship, I saw on a video that there were two radio personalities, and I have the clip, who spoke and met with Karen Reed. And during the conversations, at least they relayed that there was some claims about a drug issue. And according, not to the defendant, but according to the interviewers who supposedly interviewed her, they said that the story is completely false. They attribute this to Karen Reed. People are trying to make it more dramatic, like Colin would have a reason to hate John O'Keefe. That never happened, referring to some drug claim. He did not report him for anything. And so what we know is there is no history of animosity between Colin Albert and John O'Keefe. We know that there was no animosity between his family and John O'Keefe. The only event known is that at some point, Colin Albert's younger brother ran across John's lawn. Mr. O'Keefe supposedly yelled at him and then bought him candy as an apology. That's it. So we have an alleged third-party culprit, a very strong claim, with no evidence, no motive, no opportunity, not even present at the time that this alleged collision occurred. And so,
as a lot of people think, this happened in the basement where John was attacked and the dog, there's some kind of scuffle, you know, the way
in
the
that absence of evidence, it's not even feasible.
you know, the way there was that fooling around as Brian Albert talked about at the Waterfall Bar and Grill with ATF agent Higgins, the way they're wrestling around, you know, maybe they were wrestling around with him in the basement. Maybe it wasn't meant to be anything gone violent, but they're just roughhousing each other. And maybe one of them slipped and fell, hit their head on some barbell equipment, and the dog thought there was some kind of fight going on and started attacking. And you know, that maybe just went out of control like that. And then they didn't know how to handle it and didn't want to have anything to face justice or inquiry on. So just like decision was maybe made to get him out of the house. That could be one of the defense's arguments, right? So, but this is the kind of thing that the prosecution thinks that there has to be some kind of long linkage of history of some kind of dispute between the parties in order to say there was a motive. A motive could have formed right then and there in the basement if that's what happened. So the defense is allowed to come up with a theory on what they think happened based on the type of evidence. And there's plenty of forensic and physical evidence and digital evidence to show something happened other than what the prosecution saying happened with Karen Reed.
Colin Albert should not be brought to the stand, attacked with acts that didn't occur, that otherwise would have no admissibility. Really, it seemed to be a backdoor way to tarnish his reputation and then bind him with other people the defense would like to attack to make.
So here's what Brendan's saying. It's basically like, we shouldn't be tarnishing anybody's reputation and make it look like they could be a suspect of something involved in the murder of Officer John O'Keefe, because we're not here to get a fair trial for Karen Reed. We're here to protect government witnesses that we want to call, and we want to make sure that everything's just not challenged at all. Don't challenge at all. Their word is golden. Anybody that the prosecution puts on the witness stand, everything is the truth. Anything else contrary to what these witnesses say is an absolute lie. So that's how ridiculous and radical this line of argument is.
A general suggestion that somehow this group of people are bad people. I know at the last trial, There was pictures of Colin Albert's knuckles that were scraped, and inevitably it turns out that picture, and I think the exhibits were introduced at trial, was taken much later. Pictures taken before that point show that Colin Albert's knuckles on the 9th and 11th of February weren't scraped at all. So because he had scraped.
Well, because there's no pictures from that, what they look like that night. And maybe this happened 5 weeks later when they're trying to heal that the photo was taken. So he's not making any sense here. It's just all spin.
Knuckles subsequently, because he may have done a video that some use would maybe do and threaten somebody else, not John O'Keefe, has nothing to do with this case whatsoever. It's an attempt to introduce alleged aggression or prior bad acts, but there's no bind whatsoever. The second person that the defense would like to identify as a third-party culprit is Brian Albert. And this is some of the gross generalizations that you see with Colin Albert. No specificity, but trying to assault his general character by generally suggesting things that may or may not be accurate in just telling part of the story. They claim he didn't have a good reputation among fellow police officers. No evidence. They claim it. And even if it was so, has nothing to do with this case. Known as a bully.
You know, for them to put that in the motion, it has to be truthful. So for them to say there was no evidence, as I understand, there's a couple cops on the witness stand to talk about how Brian Albert was the type of cop that basically sucker punched other police officers and stuff like that. Basically was a bully of sorts is what the prosecution is trying to counter here. So they're not on trial for this, but you can probe and ask questions and bring up other evidence like that to show their propensity for violence.
So rumor clearly is not admissible in a criminal case. Had a history of sucker punching officers. We don't see any specificity. We don't see any evidence.
Yeah, that's a good point here, Beach Bum. He's always talking about the Commonwealth has a right to a fair trial. The Constitution is to protect the citizens against the government being out of control like these arguments are. Not the other way around.
Information. We just see a general attempt at a character assassination to portray him as somebody who is either capable or a bully. Nothing relative to John O'Keefe. Nothing.
Okay, because it doesn't involve John O'Keefe directly, the fact that he has a propensity of violence and could have had a motive to be somehow involved in this
They suggest
in this case.
and I'm not sure.
It's just absolute garbage argument
The
here.
basis for this is that he was drinking heavily that day when he went to a funeral with Mr. Higgins and another person. It is true that he was at the hillside around 9 o'clock and was drinking around 9 o'clock. So all of this information is
Yeah,
just
that's the
general
thing.
accusations about
I'm hitting
character.
pause, and it keeps
They say he
moving.
was a trained boxer because when he worked out, he boxed and he was engaged in charity events.
All right, I guess I
Someday-
can't hit pause. You're saying here my biggest pet
Back to
peeve
2000.
is insulting my intelligence. They're doing that to all of us. That is so true. I mean, this is.
Anybody in
Do they really think a jury in Massachusetts is dumb enough to believe all this garbage?
the neighborhood who has any self-defense training, mixed martial arts, or
But that's why I call the
boxing,
jury is the
target.
equalizer for all this
The fact
corruption
that
and
he's a
politics.
police officer and that he is physically fit and that he trained to protect himself doesn't make him a third-party culprit. It is this general suggestion of strength and distorted into a hopefully perceived sense of violence that it has no root at all, no root. They went as far to say he was investigated by BPD for violent conduct, but they don't give any details. If they looked, they could go online, they could investigate potentially. There is no sustained findings that are known to the Commonwealth against Brian Albert in internal affairs, none whatsoever, ever. And so to make the suggestion he was investigated by BPD for violent conduct, they provide no fact. I'll say, even though it is
Even if they heard it through other means, if there's any source of information that this guy was a bully, he's sucker punching other cops, that's a basis for them to ask the question. So they can't just go on some fishing expedition and making up stuff. But if you hear about this as an attorney, you have a duty and right
trying-
to effectively defend your client.
To suggest that he has a propensity for violence. And they don't do it very well because they provide no details. These are all just general accusations.
Oh yeah.
by
So
the defense.
back to this here, cross-examination, you're asking,
In fact, I would say.
I guess you're saying you're a medical examiner yourself. Where was the MDI at the hospital taking
not-
detailed photos, measurements, et cetera? There should have been 80 photos just from the MDI. It's nuts. Yeah, I mean, where's all the photos for this case? It's just,
Well, you can't.
it's just
alter the
out of this
character of the
world.
witness, but to simply make suggestions of bad character is not any root or tethering to this case specifically. Instead of bad character, Brian Albert was a two-time recipient of the George Hanner Award, has many, many medals of honor from the Boston Police Department, but that is not the issue. They suggest that he was involved. So they know that they have to tie him not only to the scene, but somehow to Mr. O'Keefe. And other than being at the bar that night and Mr. O'Keefe and Miss Reed pulling in front of his
They
bar
did.
that night, there is no association between the two. They say he's present at the scene of death. By all evidence, Mr. O'Keefe died feet from the street near the flagpole in front of 30.
It could be simple as because to get him off, get him out of the house, get him out of the backyard, or something like that could have happened.
He wasn't there. That happened out front on the front yard near the flagpole, about 70 feet from this house. The body was found feet from his front door, arguably, okay, 70 feet, 75 feet. He admits to being home. He doesn't have to admit he was home. Now, here is another claim without any evidence whatsoever. The defense states emphatically, computer forensic data overwhelmingly establishes O'Keefe entered Albert's house. I haven't seen that evidence. Based on what?
The fact
So
that
they're
there's
going to
different
make
flights of
offer
stairs, 3
proof
flights
to
of
the court,
stairs
and they're going to make claims
transited based on
substantiating
digital
this
evidence.
theory.
That's
They
why.
have to have proof of it. And in their motion,
Where's he
I see
making
no
up this
proof
stuff
whatsoever.
saying that there's no proof of it?
That
Has he really forgotten about this?
John O'Keefe went into the Albert house. In fact, what we see is the opposite. In the past trial, numerous people were called. Every single person that was asked stated they did not see John O'Keefe enter that home. Every single person. Now, whether you believe it or not,
Yeah, I mean, I've seen comments
irrelevant.
about that, and that could be
What's
something
relevant
as
is there's
well
nothing
where
to the opposite. There's an absence of
could there have been
evidence to
something
the
else
opposite.
that hit John other than Karen's vehicle? What about all these other vehicles
fact,
coming and
the
going?
phone
How do we know
data-
that they weren't involved in it? All of those vehicles have to be looked at as the occupants and drivers of them have to be looked at as suspects. But that was never done on this case, never done at all.
in the Waze data, in the GPS, and all the data puts John O'Keefe at the front yard, not in the house. So if they're asking the court to make a finding of substantial link and substantial proof that John O'Keefe was in the house, they have to actually give you the facts and the science and the data to support that. And I don't expect that will happen. They add that there was going to be expert testimony that the scratch on John O'Keefe's arm was from an animal or a large dog, and because Brian Albert had a dog in the house, there was some type of inference. Dr. Russell has already testified at the Lanigan hearing that she's not saying that those bite marks were from Chloe. Although it has not been decided by the court, Dr. Crosby has done molds that show that the teeth comparison is totally an opposite. And so even the defense is not saying, as I see from the disclosures, that Chloe bit John O'Keefe. Their version, which we don't agree with, is that a large animal or a dog caused these wounds. They don't say where, they don't say when, they don't say
Okay,
how.
so all right, so they didn't
And
say
so-
the third party culprit is a dog. Normally the culprit is a human being, another individual that should be a defendant. So the fact they didn't mention the dog as being the third party culprit, I think that it's fair to say the dog injuries did not cause the death. So it's an indication that something else happened other than what they're saying Karen did. And teeth comparison was junk science, as argued by the Commonwealth, says Beakey. Yeah, so
So that is not a link so that Brian Albert becomes a third party culprit. Finally, in a way to try
All the mannerisms and behavior of Brian Albert can make him totally fair game to be a basis for the defense to accuse him of being involved in something that went down that night. And all the strange behaviors, getting rid of the phones, the movement of the car, him not waking up. And where's the dog when Jen and Karen show up the next morning? I mean, all these questions, you go on and on and on. So all these things, each and every one of them is a basis as a standalone reasonable doubt.
to create some type of traction against Brian Albert. They associate him with Brian Higgins because they spent the day together, because Brian Higgins, according to them, was rebuffed because of phone calls at night. All of these general claims with no fact predicate rely on innuendo, surmise, speculation, or just the creation of an inference that does not exist. There is no evidence Brian Albert had any motive whatsoever to harm John O'Keefe. None. There is not one witness, there's not one statement that Brian Albert had any animus whatsoever towards John O'Keefe. None. He did not have the motive, he did not have the opportunity, and there is no evidence that he was involved in any way in the alleged collision that happened in the front of his yard that night.
The prosecution's theory is so far off the mark that the defense theory has more credibility. And because of that, there's so many issues of reasonable doubt that the prosecution knows their case is so weak. That's why they're trying to put all these witnesses up there and bolster them as being folks that are just in the house and had no idea what was going on. They're just completely clueless. So
finally, the defense turned to Mr. Higgins. Mr. Higgins was at the Albert address that night. John O'Keefe never went into the Albert address that night. They take very, very select pieces of information.
That's a lot of people think, Carly, that something happened and they moved about.
Tell the whole story. And from that, they want us to speculate a motive. For example, they say that Karen Reed had kissed Mr. Higgins at John's house.
They're talking about ATF agent
Higgins here now. In the text messages. According to the text messages, Mr. Higgins essentially says that Ms. Reed came up to him and planted a kiss on him. And there's quite a bit of text message exchange that you heard during trial about that interaction. And then at some point, Ms. Reed went to Mr. Higgins' house. And so there was some interest, it would appear from the text messages, between the two. Mutual, at best.
That's true.
A plethora of text messages where Ms. Reed is pursuing Mr. Higgins, looking for his time, looking for his intention. In one, she says, I was basically begging him to come over. Do you like me? Come over to my house. There are text messages talking about Mr. Higgins not having enough time for her. So there is a flirtatious relationship between the two of them. What we don't see is that somehow that creates a motive for Mr. Higgins.
Okay, Mia acting out, you're saying, how can I be fooled by the actress Karen Reed? This is not about, I'm not on some pro Karen Reed support group or advocacy group or anything like that. I'm just talking about evidence and what it takes to get a conviction and what it takes to do a case due process. The government is required to conduct a prosecution of a defendant with the constitutional parameters and framework in place. If all those just get thrown out the window and you try to hide the evidence that the defense is trying to show that exonerates Karen or at least causes reasonable doubt, that's what I'm burned about. Okay, so this is not about defending Karen Reed. I have no opinion of Karen Reed as a person. She's made some things, public statements that are contradictory. She's done that with her lawyers. I don't understand why they would do that. But the bottom line is, I'm not looking at it from the standpoint of, even if she did say, oh, I did it or I did it. The thing is, she was under the influence of apparently a lot of alcohol that night and hard liquor at that. And I've already talked about how that can cause you to have blackout of your memory and whatnot. So, and if she's being spoon-fed stuff by Jen and she sees him laying there, of course she's going to freak out if she really loves and cares about the guy. So none of that's really compelling. And if the forensic, scientific, physical evidence and physics and gravity don't align with something Karen might have admitted to, that's what's more compelling. All right. I've had a case where somebody admitted to stealing $30-some thousand. I got the copy of the formal felony police report talking about how this person had admitted to stealing. And what I was looking for when the client came into my office, like, well, how do we make restitution? Because there was a full confession. It was like a beautifully written confession to the investigating officer. And I'm like, okay, well, this is like a open and shut case. I just got to worry about getting her a fair sentence. And as it turns out, I found out that there was a confession just because she wanted to get out of the police station as fast as possible. So she just agreed with everything they accused her of doing, and they wrote it up and she signed it. And she also had some medical situation that made her want to get out of there as well. So I'm like, why didn't you just invoke your rights, right? You just said, I want rights to counsel. It'd have been over and done with. They'd taken your fingerprints and you'd have been on your way. But as it turns out, I'm like, okay, let's look into this some more. And as it turns out, she was innocent of it, right? So you can't always go by what somebody says or what they think, especially if they're in a drunken state, especially if they're under hard liquor. So I don't really put a lot of stock in that.
Higgins to want to hurt or kill John O'Keefe. The fact that they are texting together and later that night he sends a text message because I think an inference the defense would raise is that he felt like he was ignored or wanted to know what was going on with their relationship, is not evidence of motive. In all of these text messages, you never see any animosity towards John O'Keefe. Mr. Higgins's text messages.
There's an argument that they can make that not O'Keefe was aware of this, but that
it's uncomfortable.
Higgins
it's an awkward situation because both of
was
them
being ignored by Karen that night. She completely ghosted him. And that could trigger anger in him, and he could want to have some confrontation with John O'Keefe. Remember, he texted him and said, "Are you coming over?" with 3 question marks. Why was he so interested in him showing up?
Any logical connection that would support third-party culprit. Brian Higgins sent a text message saying to John O'Keefe, asking if he was coming to the home that night, and they then attached the word he lured them to the house.
Yes, I will.
I mean, we do look at this evidence not in a vacuum, but logically and realistically. Not knowing that Karen Reed was not going to come in when they arrived at the house. Is it reasonable? Is it rational? Is it lucid to think?
Thanks for keeping it clean and professional. We're trying to have courtroom level discussions here. So talking derogatory terms to the judges or even this prosecutor, let's just keep it clean. We're talking about their conduct, their actions, and the trampling of the Constitution and due process as applies to this case. So thanks for being clean.
That that Mr. Higgins was inviting them both over to the house, not knowing only one of them will get out of the car, is a suggestion that Mr. Higgins was going to kill both of them, or he was going to kill one of them, so the other one he would then set up for murder so that he wouldn't be able to see her anyways. The absurdity of the relationship between the claim and reality is so great that it will just run rampant through this trial. It would be unrelated.
My prediction is this guy has major credibility problems with juries, and his demeanor and behavior in this case, it's going to come through loud and clear to a jury. There's no way he's going to get 12 jurors to believe that Karen is guilty of murder or manslaughter. There's just no way that's going to happen.
Speculative, shotgun approach to claims that the witness will spend their time trying to explain and defend. It will distract the jury, and it will serve the purpose which the case law says it shouldn't, of taking attention off the facts at issue for the case we're here from.
Whoops. Oh my gosh. All right. So take the attention off the case that we're here for. Again, he's got this same drumbeat of you can't look at anything other than what I'm telling you to look at. This is so
Shotgun approach to claims that the witness will
shotgun
spend
approach
their
to
time.
claims. This is
trying
how
to
trials
explain
were
the
conducted in
defendant.
America. You have a
It will
right to
distract
present a
the jury,
defense.
and it will serve the purpose, which the case law says it shouldn't, of taking attention off the facts at issue for the case we're here from. And that attempt to divert anybody but the defendant is the attempt here. That's why we have three, we don't know who, but three potential third-party culprit evidences with absolutely fragile evidence. It's feeble. They, as their support, what they offer is they believe Mr. Higgins lied because he went to the Canton Police Department to do administrative work. And I think the evidence is clear that he had cars that he parked there as part of his job that he needed to clean off. So they are parsing.
And when they all left the house at early morning hours, first couple hours after midnight, there was not that much snow at that time. It was building up more towards the 3:15, 3:30 time frame when the snowplow came by. So he was easily spotted if he was there.
Words in an attempt to create a basis that doesn't exist. That there are calls between Mr. Albert and Mr. Higgins later that night. So what? They have no evidence that either of them spoke to each other. They have no evidence of conversations. They have no evidence of a conspiracy. They have no evidence of a cover-up. They have no evidence of a weapon. What we know is John O'Keefe never went in the home. And so to try to create this image based on obscure facts is not the substance that's required under third-party culprit. I know third-party culprit is a time-honored tradition and is a broad latitude, but it's not endless.
Yeah.
It can't prejudice the Commonwealth. It can't distract the jury. It can't be based on fiction. It has to be based on an identifiable theory. The cases that have allowed third-party culprit that have been reported have actual people who could be a third-party culprit, who actually have relationships to the scene or the crime or the deceased. In this case, an attempt to call Mr. Higgins a liar or create fictions about what they think he could have been doing or guessing what they want him to do is not evidence. 9 people testified John never came into the house. 9 people. There is no overwhelming evidence or any evidence he went into the house. There is no evidence of motive on any of these 3 people they identified. They've had, before the last trial, the entire trial, and was aptly pointed out, no request for a third-party culprit instruction. And then they had since then to make an actual proffer that people actually have the motive, opportunity, and intent to do this, that there's actual evidence that there's this alternative theory, and they failed to do it. To have the defense go through a trial, distract the jury, attack the reputation and character of the witnesses, and then not even ask for an instruction at the end. It evidenced the fact that there is no basis for a third-party culprit. Now, separately, third-party culprit is part of Bowden.
Man, he's just going on and on. I mean,
Defense
it's so
at the
boring
end
to
does
listen
not
to.
warrant an instruction. I recognize that
He's just walking around
challenging
lost.
the police investigation is
No one says
virtually
anything about the
an
Constitution.
entitlement of a defense. How they do it and the extent they can do it is a different story. Simply because they have an attack on the
Yeah, that's a good
police
point.
investigation does not let them use.
ARCO was the
third
main basis
parties
for their
as part of that.
inquiry, right?
And so the standard, Silva Santiago, is very clear, it's cited by almost every case, is that there has to be something the police didn't do at the time that they knew about and should have done. So at the time the police did their
Imagine this guy in front of a
investigation, it's being
jury.
criticized, they would have had to
And
have
all the
known
objections he's going to be
about potential third-party culprit
launching.
or third-party culprit evidence and didn't pursue it. And that's where the defense argument utterly fails here. Because at the time the police were doing this investigation,
Yeah,
What they
Higgins was
do-
mad.
is that John O'Keefe was on the front lawn of 34 Fairview near the street. They knew that he was dying or
Juries
dead.
want to look at the attorneys and figure which one is
And
telling the
a
truth. They both
number
know the
of
truth. So which
witnesses
one,
knew
which side is telling the truth?
that Miss Reed was saying, I hit him, I hit him, I hit him. A number of witnesses.
And then it
Shortly
falls the matter right
thereafter,
there.
What the police knew
You can't present anything
is
contrary to
that
that, right?
Miss Reed's taillight was cracked.
Right, Mr. Brennan?
And shortly after, what they learned and knew.
His jaded view of the
after they
Constitution.
got her
I
cars,
don't even know if he
part of
thinks
her
about the
taillight
Constitution,
was missing.
frankly.
So at that time, when they were doing their investigation, there was no claim of dog bites. That came months and months later. They went to 34 Fairview and they spoke to the owner, according to the witness testimony. And everything seemed appropriate. Concerned, confused, no blood, no scratches, no cover-up, no turned over furniture. There was nothing that would have alerted the police officers that there was any.
Yeah, they're definitely doing some talking about John at the bars. And he was also texting Karen, and Karen does not look at him at all. So that microdots video that you can see on YouTube, I encourage everyone to look at that. They really put a good scenario together, and they're making arguments what they think might have happened. So it's really something to consider.
Road to follow, other than the road they followed. Now they can be criticized for plastic cups or leaf blowers, but that's different. That's different. In order to have third-party culprit,
That's what they would be arguing.
have to have known
Should be
that there
arguing.
was information that targeted or pointed out a different person, and they didn't pursue it. So in the cases cited by both the Commonwealth and the defense, there are a number of cases that talk about information that was known to police at the time they were investigating, and they failed.
They're obsessed with John O'Keefe coming back to the house. That right there
that is not
should
this
probe a
case.
vigorous cross-examination.
There was nothing in any of these proffers that show actual evidence that the police knew of these later third-party culprit claims by the defense, or they knew at the time they were doing this investigation that there was any other lead.
That's what they'll be
The likely
arguing.
reason
It's a
was
reasonable thing to
if there
argue.
wasn't. The evidence for a reasonable.
That Jen was on the
police
lookout for
officer
Karen coming into the house.
towards the statements, towards the car, towards the light. And that was followed up, which led to DNA in hair and all the other evidence that followed the data. And so as a concession to the defense, they don't simply get to bring in third-party culprit through Bowden because they failed in the instant case to show a third-party culprit. That's not part of their entitlement. And mindful that if they do raise Bowden, whether they get instruction or not, it is broad. And that means the police, including any police they would call in this case, or we would call, is entitled then to share their state of mind why they did not do something. That can open doors to inadmissible evidence, privileged materials. The state of mind of the officer is relevant if they make it relevant. So we should not engage in a process where we allow witnesses to be asked questions with no ability of the defense to follow up those questions with actual proof. We should not engage in a process where witnesses, their character is attacked when it has no relationship whatsoever to this crime. And witnesses shouldn't be put through the ordeal of defending themselves based on generalizations.
Yeah, my gosh, asking them some tough questions about, hey, what were you doing? And making either direct or implied accusations that there's something else there that you're not coming clean on. That's like too much of an inconvenience, right? We'd rather just send somebody away for life in prison just because you don't want to open that door, Mr. Prosecutor, right? So again, what a shame.
About supposedly being violent.
How can this even be reality?
There needs to be
to have a guy standing up there with a straight face arguing and kind of stuff. But that's how cutthroat you will see some prosecutors. It doesn't get any worse than this one right here.
Thank you. Yes.
Just absolute garbage. All right, so I'm going to stop it there. The other thing, the other thing I want to mention is that we had the issue about Yanetti's messages between him and Karen the days of 29 February through the 2nd of March. Prosecution was trying to get that. He also had defense counsel on the witness list. And so they were trying to get those kind of emails and text messages that were held at the Attorney General's office, because they did the search authorization for those records. And when they found out there was attorney-client messages in there, they did not disclose that and present that to the prosecution office, or at least they shouldn't have. And so with Brennan trying to get that to try to prove that there was some kind of admissions that Karen might have given to Yannetti, because he was the first local counsel she went to, what that basically does is it forces Yannetti to have to be in a position that he could be defending his own advice. He could be defending the conversation. And if he's called as a witness, he has to be removed from this case. If he's a material witness, he has to be removed from the case as counsel. And I said this before, that means also the Pro Hoc Vicia counsel then need a local counsel to be able to take over. So this would like basically put a very long delay in the whole trial. And I think the judge wants to get this trial moving. And so before Alessi could even get into that, the judge shut him down after I think it was about a minute. He just said, we're not going there. I'm already going to rule against the prosecution. So the one time she was the only one big ruling I've seen that was against the prosecution, where they were really going to do something really drastic and cause a huge delay and ruckus in this trial. She did stop the prosecution cold from going down that road. But like I say, it would have been a complete disaster. And if there's that kind of a forced witness evidence kind of thing in a criminal trial, you just don't see it. I mean, he is so far off the deep end and going after Karen Read. So the question is, why is he going after her with such a vengeance? Why is he just looking the other way on the constitutional principles? Why is he trying to deny them all that truthful evidence that should be coming out? So in any event, the other thing that was out there was this motion to dismiss, but I'm not going to talk about that tonight. I'm going to cover that another night. So that's something that the judge denied because of the outrageous government conduct. You can actually have it's been done in the history of America a number of times where the government's conduct to try to go after and target a defendant is so extreme and outrageous and extraordinary, a violation of due process, that as a matter of basically punishing the government, the judge can dismiss any and all charges. So that's what the defense was asking for. And so the judge denied it and went so far beyond the norm of what was legitimate findings that it was somewhat expected. But again, it's showing another example of the significant bias in favor of the prosecution that you see from this judge. So with that, I'm going to go ahead and follow up with any other questions y'all have. So if you have questions, go ahead, use a red emoji, use 3 of them if you can, so I can distinguish them from your own internal chat. Yeah, so Alessi was talking about, it's like every defense attorney in Massachusetts would be like freaking out if a prosecutor is trying to get to privileged communications. Attorney-client privilege is so serious and so much a fundamental, long historical privilege that existed all across America for so many decades. And so if that's going to be cast away in a criminal trial like Brennan was trying to accomplish, I mean, that would send really shockwaves massively. Okay, Christine, you're saying that Karen had already contacted another attorney before she contacted David Yannetti. His name was Attorney Diamond. He was the only attorney she contacted before her phone got seized. Okay, well, yeah, that's some rainy day girl saying if you repeat the lies enough, I guess they should become facts. If you keep beating this mantra that she hit him, it doesn't matter. We got her saying she admits to hitting him, yet there's nothing to back it up. So you need something more than admission to convict somebody. You need to have some extrinsic evidence to support that, and there is none on this that's credible. How do you count for all his injuries on his on his side of his arm? How do you count for that big gash in his head? How do you count for nobody seeing him? I mean, you can just go on and on. So I'm going to create a list of reasonable doubt, and we can go over that here. Maybe still this week. Maybe I'll do it Friday with y'all. Yes, Jennifer Rank. Why does this prosecutor and judge believe they are above the Constitution? They didn't take an oath to protect the Constitution. You know, it's just one of these deals where it's sort of like that's the culture. Every courthouse, every district, every state, they can have their own culture. And if their culture isn't the Constitution and they just really sort of just try to go by and everything's sort of by who you know and what you know and all that kind of schmooze and kind of stuff that does happen, and who's playing favorites and who's got the inside track to this job and that, and you know, you help me this way, I'll help you that way, all that kind of politicking going on. You know, the Constitution can be lost in the shuffle. And yeah, there's an oath to protect the Constitution, but you know, if it's the Constitution's an inconvenience for you getting a career advancement, you know, some people can do that kind of thing. So I have no idea how Brennan thinks he's doing the right thing, because it's never going to survive any kind of scrutiny in the appellate court process. If the state courts in Massachusetts are that much of a joke that they don't toss this thing and crush it on appeal, I'm sure a federal court will at some level. Yeah, Harmony Ricky, you're saying, am I confident the jury will see through these inequities? You know, no matter how much of the truth he tries to keep out, there is going to be enough truth that comes in that I think there's no way they're going to be able to get a conviction. At worst, you'll have a hung jury, and I don't think there's any way you'll get a conviction. It's just not going to happen. And so, but they're stuck on just pursuing this mindset. And like the comment was, it's like if they keep saying it long enough, you know, sooner or later you can fool most people, and get them to believe that's the truth. So I can tell, like I said earlier, about the way they're presenting all these witnesses at the waterfall and at the house. They know they got credibility problems with their theory of the case, massive credibility problems. Fierce like Frida Substack, you're saying, do you think that the federal investigation is actually closed? If Karen Reed were to be not guilty, can the feds reopen the investigation again? Well, this is a murder case and they're investigating corruption as well. So any of this kind of stuff, even though they said it was closed, maybe they said that to make the let the state folks show their hand. So I wouldn't take that as a etched in stone kind of thing at all. Yeah, rainy day girl saying, yeah, Lucky said he could have it towed, but he knew the owners. It was odd to park there, and they could have gotten fined as well. I think he said they first give a courtesy call. They can't get a hold of him or whatever, and it's not moved by the time he makes the next go round. They could basically have it impounded and fine the owner of the vehicle. Nancy's saying, what is your opinion that Judge Bev will be interviewing the potential jurors rather than the attorneys? I think it's normal in America for attorneys to do the majority of the voir dire. The judges are normally there just to do the initial stuff, the basic foundational type stuff, but the attorneys are there to do really the kind of questioning that's going to make them feel like they are getting off the jury, the ones that have prejudices and biases against them. So if you don't allow anything other than generic type stuff, it's a wild card in what you're going to wind up with. And so I think in the end that can work against the prosecution as well. But you don't really have as much an opportunity to develop a rapport with anybody on the jury. And so that's what I use when I've had some judges like that as well. They try to make it all jury in group and mass questioning, and they try to limit the individual questioning. And so I think with this thing, it's very much a judge-controlled straitjacket, and I don't like it at all. I think it's you get better justice, you get rid of some of these oddballs, and you have less of a chance of a hung jury if you get some of these outliers, some people that have some kind of strange beliefs. And it's also a thing to develop. Like I say, you want to have trust and credibility with the jury. If you can develop a rapport with them and be able to talk to them, and prosecutors normally don't talk that much to jurors. It's usually defense counsel that try to develop a rapport. And so I think it's a good thing to answer any questions. And when I do it, I let the jurors know that this is your only time that we can have any dialogue. You can actually ask me questions, and there's no such thing as a bad answer. And so by this being so limited in that scope, yeah, it's just not as clean of a process, I would say, where you're going to have a jury that could come to a unanimous decision at 12. Well, if it's another hung jury, the state could decide to retry again. So even if it was I don't think they're going to make that mistake where 2 of the 3 were fully acquitted, and then there's this one that's an outlier that they couldn't decide unanimous vote on. So they could retry it again. I think they would. I think they'd go for a 3rd time. They could go 4th time. I mean, I don't think they're going to let off the gas. I mean, at some point you could say this is just insane. We're not going to do it. Keep doing it. And at a point where you have a mistrial, they could say it's due process. Keep going forward. But I don't think it's going to result in that. I think the public pressure and attention will maybe get some higher ups in the government of Massachusetts. I mean, this could even affect the tourism industry if this thing gets out there enough. Or they're thinking about, God, what kind of a radical, crazy rat's nest kind of justice place is that? I mean, who would want to be accused of something up in that state? You can be falsely accused, and just all your favorable evidence is just burnt up and crashed and smashed up by this prosecutor's reckless arguments. It's really a constitutional free zone up there. Yeah, I think they would, Beach Bum. I think they'd try it again. Kyle Wells, how do you feel about Karen Reed potentially taking a stand on a retrial, assuming that Commonwealth's theory of an accident is shown to be bunked by ARCA? Is there any substantial risk? There's no point for her having to testify because they and now some of her public statements could make them more enticing to want to try to explain some of those. But I think in the end, it comes down to reasonable doubt is all over this place, and they can't prove what happened. The prosecution cannot prove what happened, and they have the burden of proof. They've not met their burden of proof. They never will. So even with this prosecutor trying to hide the ball and the judge rubber stamps everything, they're not going to get a conviction. Yeah, I don't know why Lally was taken off. I think he's not experienced enough to their satisfaction when he didn't get the conviction. So they wanted to get the guy that they thought could fight this thing and bring out the most draconian type process to try to put Karen Reed through the gauntlet. Harry's mom says, in my experience, often you see people crack, i.e. tell the truth. I'm thinking the younger ones might have a harder time keeping with the pretense as time goes on. You don't see it as in court proceedings as much. People just stick to their lies, no matter how bad they come across. They generally just stick to their lies and whatnot. No matter how bad the circumstance and consequences get for them. And you know what the thing is, though, I must say also, there's a lot of people that lie habitually in court and nothing ever happens with them. The judges, they think both sides are lying and they just don't know what side's telling the truth mostly. So they just try to decipher it best they can. But you see that in civil trials all the time. People are lying through their teeth. Same thing in criminal trials. But in criminal trials, you don't want to have your defendant get on stand unless it's absolutely necessary. And I don't see it's necessary for Karen to testify, just like in trial 1. I don't see her being necessary for her to testify in trial 2. You don't have to use 3 if you even just have 1. I can see the red. Andy School, you're saying, dude, I see the new video of a car guy who wrapped arm-shaped object, 9 pounds, not 11, as John O'Keefe, hit an exact taillight and how he was hurting before breaking it into 11 pieces, then kept going. It worked anyway. I've not seen that one. I know there's some other videos like out there like that. I've not seen that specific one. Yeah, I think Lally, the main takeaway with him is I've never seen so many objections in a trial as his. It's just every time there's something that was going to hurt the prosecution's case, there's an objection, and he doesn't have to state a basis for it. It makes the whole courtroom process just look like an utter joke. And his intro phrase on so many questions like what if anything, or who if anything, all this if anything. I mean, that's like what they teach you in law school. And in the real world, attorneys don't do that like he's doing all the time. And it's such an irritant. You don't even think of the question. All you can think of is that irritating intro. What, if anything, did you do next? Well, of course you did something next. That's why you're here in court. It's obvious. Why don't you say what happened next? That's all you got to say. So he always adds this, what, if anything? And so anyway, I think he was propped up to do it. I think most attorneys in the office wouldn't want to go near this case, and he probably was the one that was forced to do it for career enhancement or something like that. Why aren't any other attorneys in the office handling it? They got a team of 50 or 60 lawyers there, and they don't want to take this on. They have to hire somebody. I think it's up to $230,000 now. They've paid this Hank Brennan. It's I think that kind of stuff is automatically you're going to get skewed results. You're going to get just outlandish type of actions by the prosecutor, because they're getting paid to go after people, and they're paid by the hour. If you pay somebody by the hour to go after somebody, and you're paying them more than they probably make in private practice, you're going to have a lot of slash and burn maneuvers going on. Jennifer Rank, you're asking, do I believe justice will prevail when it reaches another jury? Will the state dare try her a third time? I think that she will prevail. Justice will prevail, which is the reasonable doubt. Like I say, I'm not here to say she's innocent. I'm just here to say the due process of the Constitution is such that this thing has got reasonable doubt written all over it. Okay, and the forensic type evidence I discussed, where I said she has an alibi, and if you look at all these other actions and behaviors of the people that night, it's highly, highly suspicious behavior that's not consistent with somebody like Karen, if she was guilty of it. All these crazy things from these other witnesses would not be happening. Caroline in Leiden, I think that's Germany, says typical scapegoat collusion after the fact behavior. The previous jury stated they didn't listen to Art because they thought they were hired by Karen's insurance. Yeah, that's the whole reason why they didn't want the FBI hiring, the U.S. Attorney's Office hiring to come in, because they wanted this kind of confusion by the jury. So that's how corrupt criminal justice can be in America when you have prosecutors trying to hide the ball like that. It's just so disgusting. It just turns my gut. What strategy would I use to prove Karen innocent? Well, I think, I mean, there's so many strategies. The voir dire one is a critical piece of the trial strategy. And if you're cut off the knees like this, that precludes a lot of stuff, but it's not the end of the road. What they need to do is have a consistent theme and theory and weave that through all the witnesses. They need to do tougher cross-examination. They need to intimidate these witnesses more when they cross-examine them. And they need to know that they know, when I cross-examine a witness, they know that I know what the truth really is through my questioning. And I'm not looking at notes. I'm looking at them eyeball to eyeball, and they're going to be squirming because they know that I know that they cannot answer the detail level of questions that I pose at them. So there's so many different, a lot of it has to do with techniques and strategies. A lot of it's personalities. Different personalities of lawyers are different. I always say you got to be yourself when you're doing trial work. You can't try to be somebody that you're not in your personality and whatnot. So in any event, I think that they have the likability factor way over this guy Brennan. And so, and we have Yannetti, he's a local guy. And I think if you look at Alessi, that guy's, not only is he super brilliant, but he comes across as like a very conscientious, sincere kind of guy. And it's a guy you can trust. So I think between him and Yannetti, they're going to do well. I think that Ms. Little, I forget her first name, Michelle, I think. She comes across credible. She's not as sure on her feet in the courtroom and as confident as the others, but they'll assign her some lesser roles. And then you have the Alan Jackson attorney, which he comes across more flashy. I think his voice comes across well. It's an easy listen to voice, which I think is always helpful for an attorney. I think he comes across well in that regard. I think he can be tougher on witnesses, and I think he can, if they would call out the fact that all these witnesses for the government have their attorney sitting in the room there, I think, especially law enforcement witnesses, that is so odd and bizarre that that's the first thing I'd jump all over the witness on, and have more righteous indignation on what these witnesses are trying to do and what the prosecution's doing. So it's just different ways of handling it. But in any event, that's sort of it in a nutshell off the top of my head. Yeah, the red question marks, there's emojis. So they're not on the keyboard, they're emojis. That's all I can tell you. Lisa Burton, I'm afraid she's going to be convicted. Yeah, I mean, it can be scary when you see a prosecutor this going out of control. It can be scary. I can sit there and wonder the same thing, and it's scary. Marine, you live 20 miles from that Constitution-free zone there. Yeah, the Commonwealth's now in a position where they can't lose face. So even when they lose, they're going to blame the jurors. Yeah, they're just going to, blame the jury for being stupid. They got tricked by the defense, all that kind of garbage. Beachman asking, any chance the defense gets used demonstratives in closing this go around? I sure hope so. They need to really argue tougher and more, get more stern in their arguments, more forceful, have more power behind their voices when they argue. If something's really crucial, your voice needs to be stronger and more powerful and to get the point across, if you talk monotone the whole time, it's not going to have the same effect to the judge. You really need to get the judge's attention, including when you're cross-examining witnesses. So I know Alan Jackson, he got more in the face of some of the witnesses that way on different points. So I would do it also with the judge, and I think they're probably worried about it being pro hoc vice. They can't be as stern and tough with the judge, but I think they need to. Otherwise, they're just going to get pushed around too much. Eva, you're asking, do you believe it's far? I think you're trying to say fair that some of the witnesses are threatened. Is that what you're asking? I'm not sure. The first firefighter did not appear credible when he was echoing Jen McCabe's narrative. I hit him. I would say threatened. I'm not going to talk about what's going on with Turtle Boy. I'm just trying to focus on Karen. I think that any kind of messages between the two, could that come back and hurt Karen? Yeah, it could. But keep in mind, they tried to indict her for that and didn't come out. Where she was no bail, they didn't want to indict her for trying to intimidate witnesses. And what they say is also intimidation of witnesses is more harassment. It's like a simple ticky-tacky misdemeanor. It's not actually some kind of felony or a serious misdemeanor where they're trying to obstruct a witness from testifying. So I don't know. I'm not going to comment on that right now. Jennifer Rank, you're asking if I think the DAs, prosecutors, et cetera, are having private meetings regarding possible doubts, public disapproval. Do you think they see the total mess and just think they cannot backpedal? I think they got their head in the sands and they don't want to listen to any of the stuff going on. I think they try not to listen to any of the social media scrutinizing what they're doing, and they're just going to go after this, and they're not letting up. They're just going to keep pounding away. They don't care what fools they make of themselves. What a joke they treat the Constitution. It's almost like a sport for them, and they're in it to win it. When's the last time someone lied on the stand and got charged with perjury and get time in jail? Never. Yeah, I know. I know one time I tried to get somebody prosecuted for making up a false accusation that caused a huge investigation, caused a lot of people to be in a panic state on a military base in a deployed setting. And they admitted to lying. And I wanted that person to be harshly treated and get court-martialed and face some many months in confinement. And that was pretty much poo-pooed, because lawyers cannot tell commanders how to act on stuff. It's we can only advise. We don't have ultimate control in the military system. But there was somebody I know when I was an ADA in Texas, I was about to prosecute somebody before I deployed to Iraq for perjury, because it was a drug case. We went to jury trial, got him convicted, and he had accused a cop of planting drugs on him. So I was going to charge him with perjury after that. I don't know if he did get charged with perjury afterwards. I know in Florida there's some kind of stats that they kept track of that somebody shared with me about a year ago that indicated that they do charge perjury and get convictions in Florida. And it's a lot more than you think it is. Like maybe, I don't know, like maybe 120 a year throughout the state. So it does happen. It's just not something you see commonly in any particular courthouse. Yeah, grave concerns. Okay, yeah, I think I'd heard that it was first jury trial for, you're talking about Lally as well as first criminal case. So yeah, it's like, let's get Mikey, right, to try this thing. It's summer every day. You're saying the Despicable State have now changed the time when they think John died from 12:45 to 12:30 to work with when Karen was hooked on John's Wi-Fi. Yeah, that's what I said for the alibi, that they actually changed it from the beginning of trial one to the end of the trial. They sort of like uh, did a quick spin maneuver to and hope the jury didn't catch that. Patty B, yeah, I talked about it earlier tonight. You're asking, did I see that Judge Cannone ruled that the attorney-client privilege was denied? Shocker, there's even farther. Like I say, the ramifications of that were such that this thing could have blown up and wound up having the trial a year and a half, 2 years down the road. So I think she just wants to get this off her deck. I think she probably is listening more to social media, blasting away at her bad rulings. But do I think it's going to affect the underlying politics nature of it? No. Marina's 100. You said I'm one of the taxpayers putting the bill for the Hank Bryan show and not happy. Yeah, that's Gary B. You're saying nobody will ever prove this, but it disturbed me so much. John's clothes looked washed, faded blood stains. The tooth holes were fluffy, blood that would have been dark from that head wound. Yeah, there's just I can see your point there. There's a lot of things that just don't add up. Yeah, I think we're sick of the injustice of it. That's what I think the most of the sickening stuff is about. And you just can't believe it that this thing goes on and on. Things favorable to the defense is keep on getting objected to by the prosecution. Yeah, it's where you going to see something this bad in a criminal trial in America? Oh, here we got Bev's buttload of discretion. I'm a CB. Did you ever work with any of the Bs during military time? I did not work with the CBs, but I stayed in some of the military housing that they had in different parts in the Middle East. So I'm trying to think where that would have been. Different parts of Iraq. There was a lot of them I remember were made out of plywood and stuff like that. They were really good. What CBs are is basically engineers for the Navy. Army has a Corps of Engineers, and the Navy has a CBs. So they don't just do that kind of stuff on the sea or on shore. They also go inward, hundreds and hundreds of miles to get their engineering tasks done. So thank you for your service. All right, so we're going on hour 33. So let's see. Okay, Marines 100. You're saying mostly all people I know here in Norfolk County are free care and read folks. I am. Have my sign. We'll be there soon. Put my money where my mouth is. Rosemary Gallagher is saying a tail like the Lexus wouldn't shatter hitting an elbow, but maybe the elbow would shatter. Yeah, I mean, there'd be broken bones and stuff like that, massive bruising. Gary Rubner, you're saying, do I think Alessi will do most of the crosses? No, I think they're going to divide it up. Kokomo, Indiana, you're saying got rid of the dog, painted and refloored the basement, then rehomed the family. I mean, that's the kind of stuff the defense should be able to talk about. I mean, what's this prosecutor to say? No, that's not relevant. None of that stuff is relevant. How they acted. I mean, is he going to object to all this indicator that that they're acting suspicious? I just wow. Can the judge keep that out? Would the judge possibly rule and say that you can't have this third party culprit after allowing it to be introduced, although not as strong in the first trial? I think she sort of like has to do it because it was done in the first trial. Is she going to maybe craft somewhere she says, well, you can infer it, but you can't directly challenge the witnesses or argue who done it? I mean, that's if she does, that's just another guarantee that it's going to be um, that's going to be reversed on appeal. Okay. All right. You like Jennifer Rank lights a Constitution free zone. You know, the thing is, another thing I do as the defense counsel, man, I would get after the judge being in her biased rulings and constantly saying, I'll allow it when she should be saying overruled. She's got all this this affinity for the prosecution that she doesn't want to like hurt their feelings. It's just so obvious. I've just never seen anything like it. Unity was louder and animated today. Love to see it, says Carrie B. Tall Glasser saying Hank's voice will lose the jury after day one. That's what happened with me. If I was on a jury and had to listen to this guy, I mean, granted, I have a different experience on what's good arguing, what's bad arguing, but yeah, part of his personality and voice and how you come across. So yeah, it's defense definitely has an advantage in that regard. Bugs Bunny Brown, you're asking, do I know this prosecutor's records for wins versus losses? I don't know. I have no idea. And like I've said before, people can try a lot of cases, doesn't mean they're any good at it. So I don't know what his record is. Ellie, you're asking, what do I think about Brandon's reason that Higgins can't be a third party because the feds investigated him and didn't charge him? I mean, that's such a garbage argument. They didn't charge him. Well, because everybody had their lawyers and they all said, we didn't know anything. We don't know anything. And you know, they don't have the digital evidence to contradict these folks and prove that they did it. But that doesn't mean that it couldn't have happened. Because none of the witnesses so far admitted to it, that means that they're not going to ever admit to it, and they won't ever admit to it even if they're cross-examined. Maybe a withering cross-examination will get somebody to blurt out something out, or they admit something. So you know, you got to allow defense to do their job. Constitution requires it. Yeah, Mr. Monk's understudy, you're saying trial one, Judge Bev wouldn't allow the defense to mention in their opening statements, third-party culprit defense, the defense obliged. Is this normal? Should they fight for it in trial two? I think they even admitted to it. If I remember right, they said they weren't going to talk about it in their opening again and to try to like use that as a basis. Well, we're trying to do the same kind of thing we did in trial one. We're just not wanting to add the names this time. So I don't know. I'd be coming across a lot stronger and I'm more strenuous in my arguments. And calling the judge out on her the appearances and the dress downs and saying stuff like Alan Jackson to Alan Jackson saying, you know better than that. That's really bad things for judges to do, to try to dress down a lawyer like that in front of a jury on a murder case. Call a sidebar and chew him out. You don't do that in front of a jury. We have the retired New York, North Carolina Highway Patrol officer. Thanks for joining us again. You're saying people are talking about Proctor taking the fifth. I don't see him doing it. If he does, it will perk up the jury. Being his lead investigator, and in my opinion, they won't believe a word. I mean, why isn't he brought up on federal charges for deprivation of civil rights? There could be some kind of civil rights action against him, right? The way he treated Karen. That's something I'd be probably be bringing up on cross examination and tie him to some federal crimes for what he's done on this case. Tall was saying he believed Hank admitted the taillight was cracked. Gary Rubner, you're asking why is Higgins still with the ATF? Well, there's nothing they can pin on him directly right now. It's just suspicious behavior. So he still has his clearance in his job, I'm sure. So yeah, I mean, that's a something that he's a civil servant, and civil servants have all kinds of rights and whatnot. Even law enforcement have rights. The amount of rights that federal workers have in America is like really significant. You have to do something really severe to get fired or lose your job or get demoted. And it has to be documented. You have to be counseled. It's a huge burden to try to hold people accountable. And most supervisors just don't even try. It's too much paperwork. I've seen enough of that in my military career. Andy School, you're asking about whether dog DNA would have been present for medical examiner. Yeah, I was wondering that too. Did they even test for that? Did they look for that? So I think that it might not. They would find it on the clothing because I don't know that any of the clothing punctured the shirt, where they'd actually have it on the skin. But there's probably both, I guess. Even if it didn't, you don't see puncture holes. Yeah. So, officer, you're saying Higgins violated federal law. Yeah, in a lot of the arguments that Brennan does, he like tries to sensationalize it so much. He'll say like, I'm not saying it's quite perjury, but what the defense is doing is, and he's putting all these like big accusations that he then takes away, and then he says, but it does look like. So anyway, it's just that kind of stuff is just so. It's just so nauseating to see attorneys like that. I just, I would. I would call him out. I'd just crush him if I was going against a guy like that. He would not be getting away with that kind of stuff. Phoebe Beecher saying, "Well, I play Nettie soon." His response to Brandon today, he was firm and so good. Yeah, I mean, he walked through a lot of the stuff. Is very logical and very cohesive arguments. They're very factually based. I think that, like I say, they could have gone more into the forensic evidence, tied in more. How that shows Karen was innocent if Karen is has an alibi in that sense, showing some innocence, then how does that tie into how these injuries happen? How to tie it into ARCA injuries more. So, but overall, I mean, he gave enough to have the judge rule in his favor. But who knows with this judge? I just don't trust her at all. All right. So with that, let's see. Officer, you're saying if I had taken my cell phone and got messages deleted from a higher agent that I was part of off duty, I would lose my job. I can assure you. Yeah, and state rights aren't anything like they are in federal rights for employees. So it's a whole lot different in states. It's much easier to get rid of employees in the state system and cities and county system than it is for the federal system. Harry's mom, you're asking how I ever seen witnesses have their own attorney. Well, they do that now in the military. They give all the victims their own attorney, whether they ask for it or not. And that is not something that prosecutors like to have. They want to talk directly with the witness. They want to know firsthand, not have any coaching from anybody else about the witness. And it really, what it does is help create reasonable doubt, because the attorney can try to polish up the weaknesses of the witness, and that's something the prosecutor needs to see firsthand. If the witness has credibility problems, stuff like that, you don't want them lawyering up and hiding behind a lawyer. But that's something that's sort of like spun out of control with all this, the changes to the Uniform Code of Military Justice based on the congressional concerns that too many crimes are swept under the rug. All right, so with that, yeah, Linda Mon, you're saying lack of investigation is practically laughable. That's so true. So with that, I'm going to go ahead and sign off. Thanks for your support for this this look at the injustice that's going on there in Massachusetts. And I'm going to roll out several more. At least that's my plan here for this week. And I will talk about that motion to dismiss, just like I talked about the other motions today. So I'm not sure if I'll do that tomorrow, but I'll try to give you guys more advance notice of that, more than a couple hours anyway. So with that, you all have a safe evening, and have a great day tomorrow. Thank you.